Well, first, let me start by saying thank you to everyone who's joined us so far. And my name is Carol Levine, and I am the chair of Courts Matter Illinois and one of the founding members of Courts Matter Illinois. And I'm grateful for all of you for joining us for this webinar, which is the fourth in our series, Courts Matter to the 2020 Elections. This is our webinar on Courts Matter to Education. Before we jump into the webinar, a few housekeeping items. All of your microphones are turned off, as are your cameras. You'll be able to see all of the speakers. They can't see you, however. So if you have a question at any point in time during the webinar, you'll notice at the bottom of your screen there is a Q&A box. Please put your questions as they occur to you in that box. We will get to questions towards the end of the webinar. If you have a comment or you want to note something or you want to refer to something, please use the chat box, which is right next to the Q&A box, for those kinds of things. We will save those things and so that we can refer back to them at the end of the webinar. Also, this webinar is being recorded and you'll be able to pick it up. We have a YouTube channel so that you can pick up the webinar when this is over. It usually takes a day or two for us to get it up on the YouTube channel. So don't be overly anxious if you can't find it right away. Okay, I want to give a few thank yous. We do have some organizations that have been sponsors of these webinars in the series. So I want to thank those organizations. Chicago Women Take Action, National Council of Jewish Women, Chicago North Shore, National Council of Jewish Women's State Policy Committee, and National Council of Jewish Women South Cook Section, Planned Parenthood of Illinois, the American Constitution Society, Illinois, National Employment Lawyers Association of Illinois, and the Citizens Advocacy Center. With that, I also want to give just a little bit of background on just what Courts Matter Illinois is and what we do. We are a coalition of diverse organizations and individuals working to ensure a federal judiciary that's comprised of judges who are committed to upholding core constitutional values. What are those values? They are things that include voting and civil rights, workers' rights, freedom of speech, the separation of church and state, and the right to privacy, among others. Some of the things that we do in Courts Matter Illinois is that we educate the public and our elected officials about the importance of the federal judges who sit on the U.S. District, Circuit, and the Supreme Court. We do that by doing things like these webinars. We provide information to the community about the judicial nominations process and judicial nominees who will impact our constitutional and other fundamental rights. We support a judicial nomination process that's fair and identifies well-qualified, diverse, and unbiased nonpartisan nominees. We mobilize our communities to speak out and take action on federal judicial vacancies. Courts Matter Illinois monitors and takes action to ensure fair consideration of federal judicial nominations because of the immense power held by the individuals who hold lifetime seats on the federal bench. That's what we're about, and that's what we do. So, having said that, I want to give you just a very brief overview. Some of you who have been on our webinars before may have seen this PowerPoint, but just so you know, I actually change some of the slides every time we do this. So I'm going to give you a 5-minute overview of what the federal judiciary is and how it works. So here you go. This is Federal Courts 101. Next slide. Okay, the federal court system has actually 3 branches to it. The Supreme Court, which most of you know about, with its 9 justices. The U.S. appellate courts, which have 12 circuits and 179 seats. That's 179 appellate justices. And the district courts, which they vary by circuit, but there are 686 district judgeships. So what you need to know is that the Supreme Court they're asked to hear about 7,000 cases. They only hear on an annual basis about 80. And what you need to know that this year, they heard the fewest number of cases in a great number of years. They heard less than 60 cases this year. Next slide. The federal courts of appeal, or circuit courts, are divided into various districts. And if you look at this map, you'll see that Illinois sits in the 7th circuit there, and that there are only 3 states in our district, Wisconsin, Illinois, and Indiana. We're one of, in terms of the size and number of states, one of the smaller districts. The federal courts, however, if you look at the little slide to the left, heard over 400,000 cases in 2018. That's a lot of cases compared to the number that the Supreme Court heard. That's why we were concerned about the whole federal court system. Next slide. Okay, so here's how the nomination process used to work. When there was a vacancy on a federal court, the President of the United States consulted with the home state senators in whatever state the vacancy was for their recommendations. Then those recommendations would be vetted by the White House and a nomination formally announced by the White House. And the home state senators, if they approved that nomination, would return what was called a blue slip, simply a blue piece of paper that said, okay, we approve, go ahead with that nomination. The nomination would then go to the Senate Judiciary Committee to discuss and interview that nominee. A yes or no vote, a yes vote would send that nominee to the Senate, the full Senate, for approval by the Senate. That's how it used to work. Next slide. This is how it's working today. When there's a vacancy created, when the vacancy is there, the President now consults basically with the Heritage Foundation or the Federalist Society and other pretty right-wing organizations, but not necessarily with the home state senators. They suggest candidates who are vetted by the White House and formally announce nominees. Pretty much blue slips are now ignored. Occasionally they are used, but that's not the normal process anymore. The nomination then goes to the Senate Judiciary Committee. Hearings are very rushed. Sometimes they are what is called stacked, which means that multiple candidates are heard in one hearing. I've even heard the process called the rocket docket, which means they're very quick hearings. Committee members may get 5 minutes to question multiple nominees. A yes vote, again, sends the nomination to the Senate for confirmation by a vote in the Senate. Next slide. A number of processes that allowed for debate on judicial candidates on the Senate floor, debate of almost up to 30 hours, or even a filibuster on the Senate on these nominees, were set aside at the end of the Obama administration. So those no longer exist. The majority leader, that would be Mitch McConnell, can now call for a vote on these nominees with limited time for debate. That time is 2 hours, and that's it, on the floor of the Senate. And it takes a simple majority to confirm a judge for a lifetime position. With one party holding the majority of seats in the Senate, votes on the nominees, most often in this time period, are along party lines. That's how it happens with the Senate when the vote comes up in the Senate. Next slide. Today, and this gives you a sense of what the courts look like overall. This is the makeup of the courts. We had been moving towards a lot of more diversity in who sits on these courts. But in the last 3 years, the majority of the nominees have been male, they have been white, and that's who they've been. So the makeup of the court now doesn't really look like the population of our country. And if you look at this chart, you can get a sense of the US population, that would be the yellow color on this chart, and the sitting federal judges, that's the black lines on these charts. And you can see that diversity is not part of our federal judiciary at this point in time. Next slide. So the question becomes, what can you do? Well, first of all, pay attention. Consider the federal judiciary when you think about what you should be concerned about. Raise awareness, use social media, write a letter to the editor, talk to people about the federal judiciary. Call your senators and urge them to reject extreme or unqualified nominees. Ask your networks, especially people in other states, to call their senators and talk to them as well. Educate other people on the importance of the courts. Connect it to whatever else you care about. Make sure the courts are part of what you care about. And most importantly, make sure you vote. Voting will help us ensure that we get good people making decisions about who sits on our courts. I think that's the end of the 5 minutes on the courts. Hopefully that wasn't more than 5 minutes. So now I'm going to turn the program over to our moderator, my friend Dana Palmel, who is a member of the steering committee of Courts Matter Illinois. And I'm going to tell you a little bit about Dana, and then she's going to introduce our panelists who will take over for the rest of our webinar. Dana is a nonprofit institutional advancement professional at Chicago-Kent College of Law. After graduating from Washington University in St. Louis with a neuropsychology degree, she served as a volunteer coordinator for Legal Advocates for Abused Women, a clinical coordinator for a forensic neuropsychology clinic where she administered IQ tests, and a sales executive for various marketing and communication businesses before she went to law school, where she focused on public interest law and specifically access to equitable educational opportunity. In her spare time, she helps organize events like this one as a director of programming for the American Constitution Society Chicago Lawyers Chapter, a member of Courts Matter Illinois Steering Committee, and a member of Reform for Illinois Board of Directors. Dana attended both public and private primary and secondary schools and has an adult child who spent his entire primary and secondary schooling in Chicago public schools. Dana is kind of a guru on education stuff and likes to dig in when it comes to this issue. So it's my pleasure to turn this webinar over to Dana, who will lead us into the subject. Take it over, Dana.
Thank you so much, Carol, and thank you everyone for joining us, and to all of the partner organizations that co-sponsored this. In my humble opinion, this is a critical issue in democracy, where we have voters who need to be educated about the topics that will be impacted by the elections that they participate in. I am super enthusiastic about this topic, but nowhere near as qualified as our two wonderful speakers today, and I want to thank you guys for joining us. To introduce you to them, Tacy Flint is a partner in the Supreme Court and appellate practice at Sidley Austin LLP. She works on major commercial and constitutional cases in state and federal courts around the country, including the U.S. Supreme Court. Tacy maintains a robust pro bono practice in which she works primarily on cases involving education equity, immigration rights, and fair elections. Most recently, Tacy was one of the lead lawyers litigating Gary B. v. Whitmer, a case in which Tacy and team won a landmark victory on behalf of Detroit school children. The U.S. Court of Appeals for the Sixth Circuit in that case became the first court to hold that the U.S. Constitution guarantees to all children a fundamental right of access to literacy. Prior to joining Sidley, Tacy served as a law clerk to Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit and Justice Stephen Breyer of the U.S. Supreme Court. Amy Meek is a senior counsel at Chicago Lawyers Committee for Civil Rights, where she works to protect and promote access to education by addressing the individual and systemic barriers that disproportionately impact historically disadvantaged communities, using an explicit racial lens. Amy previously worked as a senior attorney at the American Civil Liberties Union of Illinois, leading the organization's strategy and advocacy for advancing women's rights and gender equity in Illinois. She also engaged in litigation and policy advocacy efforts on other civil rights issues, including freedom of speech and voting rights. Before joining the ACLU, Ms. Meek taught at Loyola University of Chicago School of Law as the Civitas Child Law Center's Policy and Legislation Clinical Teaching Fellow. Ms. Meek has also served as Reentry Coordinator and Deputy Chief of Staff for the Mayor's Office of the City of New Haven, Connecticut. Thank you so much for joining us today, ladies. And to get us started, presumably everyone who has joined us today cares about education at the very least, and is curious at the very least about how courts impact education. So it would be great to hear from both of you about why folks should care about courts and education.
Well, I'm happy to start. So both federal and state courts play a really significant role in education. Most public education, of course, is handled at the state and local level, not by the federal government, but the federal Constitution still applies to the actions of state and local governments. And so federal constitutional limitations apply in determining who gets to go to school, who gets to go to what school, what kind of education they get when they get there, and what rights students have while they're in school. And we'll talk in a lot more detail as this goes on about what interventions federal courts have been willing to make with state and local school decisions, and what interventions they've declined to make. But they've played a key role. Some of the Brown versus Board of Education, which I know we're going to be talking about, is probably way up there among the most famous Supreme Court decisions in all of US history. And it's far from the only one.
Yeah, courts matter to our clients and the populations that we serve on a multiple different levels. So on an individual level, we represent students who are facing expulsion from public schools, Although those hearings are administrative, they're not in front of a court. The contours of a student's right to due process to that hearing, were set out by a U.S. Supreme Court opinion, Goss versus Lopez, which still applies and basically sets out the type of hearing and notice that students can expect to receive when they're facing exclusion from school. And and we've used both that ruling and also other court rulings interpreting the Illinois School Code as well as federal laws in advocating for students and occasionally in appealing expulsion hearings to a court. In addition, at the district level, our organization litigated a school closing case in Chicago Public Schools. So advocating on behalf of a group of parents and students whose school was facing closure, National Teachers Academy by Chicago Public Schools went to court to seek an injunction to stop their school from being closed by CPS and won in that case. So that was an incredibly important court victory at the school level. Recently we've seen that federal courts have played a really important role in even determining how much money schools will receive from the Federal CARES Act. So the interpretation of the federal allocations of money to school districts was challenged in court. Betsy DeVos's administration had taken the position that it required significant portions of that money to go to private schools. A number of states and school districts took her to court and were successful in getting a court to weigh in on that interpretation. So that's a dollars and cents issue. So not just on the individual level, district level, the state level, courts matter to students' rights to pursue an education.
So, and we've talked a little bit about some of the cases that are historic, and that, for instance, Tacy referenced Brown versus Board of Education, which everyone has heard of at the very least, if they're not intimately familiar with it. It's a 1954 Supreme Court case that overturned the separate but equal doctrine, which, as a violation of equal protection rights, which put an end to Jim Crow, at least on the books, right? And for those who aren't intimately familiar with it, it was a case where the litigants were looking for more equitable access to education for their children who were Black, and it held that schools could not be desegregated, at least not as a matter of policy, according to the law. It's been a struggle ever since. And the evidence statistically is that schools are more segregated than ever. And certainly there have been ongoing court decisions, federal and Supreme, that have affected the quality of one's local school districts, which varies greatly from one school district to another. So among some of the other cases that have impacted that, the lay of the landscape, so to speak, as far as what sort of access one has and what kind of education one has access to. There was also San Antonio v. Rodriguez, which is a 1973 case, the year I was born. And not a lot has changed since then, despite Tacy's great litigation and Amy's work on behalf of students on a local basis. San Antonio held that differences in school district funding, which clearly impact the quality of education available to students, were not a violation of the law. And essentially, for non-lawyers, the judges said, we don't know how to evaluate what is quality education and what isn't. That's not our area of expertise. And if we were to look too hard at local school district funding, then we'd have to look at local funding for fire departments, police departments, all different kinds of local funding schemes would suddenly be at issue and the courts would be flooded. So we can't touch it. But they did give a hint at how to move forward to get better, at least a more equitable funding, if not more equitable education, by saying that a total denial of access to public education might be a violation of law. So San Antonio has basically been held to say that there is no federally protected right to public education. States have taken on that battle under state constitutions. And a lot of public interest attorneys and pro bono attorneys have been fighting that fight, both on a state and federal basis. Not too long after San Antonio Plyler v. Doe, which is a 1982 case, said that in fact a total denial of education to undocumented immigrants is a violation of the Constitution. And in part they referenced creating an underclass of illiterate citizens. And I'm sure that Tacy will speak more about that case because illiteracy was very much, from my civilian perspective, one of the issues at the heart of Gary v. Whitmer. Tacy, do you want to talk more about how the courts have impacted, those cases have impacted your work?
Yeah, sure. So maybe it would make sense for me to talk about Gary v. versus Whitmer now, since we've had a couple of references to it so far. So this is a case, I'll talk about that and then go back over how the historical cases apply. So my firm, along with co-counsel, brought a lawsuit on behalf of a class of school children attending 5 public schools in Detroit. And the premise of the lawsuit was these kids were having such an abysmal educational experience at their schools that they were deprived of access to literacy. In other words, they were going to school every day as required by state law, and they were not getting an education there. They were not getting even the most basic form of education that would enable them to attain literacy. And to make our case, we alleged both facts about what school was like. So kids would go to school and there would just not be enough teachers for all of the classes. So for example, an 8th grader would be teaching 7th graders because there wasn't a teacher. Or kids would be watching Kung Fu Panda 2 because there wasn't a teacher. There weren't enough books, so multiple kids would have to group around a single copy of the text for the day, and homework was out of the question because there weren't enough materials for people to bring home. The physical conditions of the schools were themselves imposed an obstacle to learning. Like the buildings were freezing in the winter, kids wore coats and could see their breath, or the buildings were, heater malfunctioned, and so the buildings were excessively hot, kids passed out. Kids vomited in class. The toilets didn't work, water fountains didn't work, there weren't enough chairs or desks, just really shocking conditions. So half of our complaint detailed the actual on-the-ground facts in these kids' school lives at these 5 schools. And then the second half of our complaint said the result of school conditions like this is exactly what you would expect. When a kid goes to school and has no teacher and no book and no desk and has to wear a coat all day, they don't learn. They are not given the tools that any kid would need to learn. And so proficiency rates at these schools were literally 0 in at least 1 or more categories, so including literacy. So we said, there's all this federal case law that people have read to say that there's no constitutional right to education. As Dana mentioned, the San Antonio versus Rodriguez case is the key one. And we said, so everyone read San Antonio versus Rodriguez to say the federal constitution doesn't guarantee access to education. But San Antonio versus Rodriguez leaves this one opening, as Dana said, that if what states are providing is below a basic threshold, minimum threshold, then maybe it does violate the Constitution. And we said, this is that case. It does violate the Constitution for kids to have to attend school day in and day out and be provided no education, essentially no meaningful education. So we argued that this was, in legal constitutional terms, a violation of the federal due process clause of the 14th Amendment of the Constitution, in that kids have a right under the Constitution to a basic education, access to literacy, which they were not being granted. So critical legal precedents in our case were the three cases that Dana just talked about. So Brown versus Board of Education, we all certainly recognize as being the case that struck down separate but unequal. And it held that legal segregation in schools, legal racial segregation in schools is inherently unequal. Separate is inherently unequal. And so that violates the Equal Protection Clause. It also talked quite a bit about the importance of education. And it said that providing a public education is the most important role of state and local governments. Then San Antonio versus Rodriguez, Dana discussed and I've already mentioned, said, as long as everyone's getting something, we're not gonna wade into saying whether everyone gets the same amount, but we're leaving open the question of what happens if kids get nothing. And then Plyler versus Doe is a famous case for the holding that Dana described completely accurately, which said we can't, a state, in that case it was Texas, cannot deny a discrete class of school children an education. It creates a permanent underclass of children marked by the stigma of illiteracy. And so it struck down a Texas statute that required children who could not prove their lawful presence in the United States. It required those children to pay tuition to attend public school, whereas everyone else got to go to public school for free, as we generally associate with public school. So that all got struck down. So we said in our case, we are the case that the Rodriguez court talked about by having these schools, by the state of Michigan allowing these 5 schools to sink to the level to which they've sunk. They're functionally excluding the students in these schools from the Michigan system of education. It's just like the class of immigrant children in Plyler versus Doe. And the state is failing its most important duty under Brown versus Board of Education of making sure that kids have access to education, access to a basic education. And amazingly enough, we won in the Sixth Circuit. It was the first time, so Rodriguez left that question open, but our decision was the first time a court had actually said, answered the question by saying, yes, there is a violation of the Constitution here. And the court held that there is a fundamental right of education, of basic education, for all students in the US, all children. And it made 2 critical points in reaching that holding. First of all, it talked about the role of public education in the history of the United States. It noted that at the time that the 14th Amendment was ratified, most and now all states guarantee a public education in their state constitutions. And it talked about how in the history of the United States, withholding education is a way that states have prevented African Americans from achieving liberty and equality. So it's that the court said access to literacy provided through public schools has been viewed as a prerequisite to the exercise of political power. And secondly, it said public education is implicit in the concept of ordered liberty. What that means is to have the type of democratic society that we have, everyone needs to have a basic education. Access to literacy is necessary to exercise basic rights and is necessary to participate in civic, political, and economic life in the US. So it said, the court finally said, education is the great equalizer. It's sort of the basis on which American democracy is founded, that no matter what circumstances to which you are born, you can achieve equality and progress in the United States through education. And so no child can be deprived of access to liberty, access to literacy. So we won in the Sixth Circuit. And then fortunately for us, we were able to settle the case before anything bad happened after that. We, had the case stayed alive, the next step would have been rehearing by the full Sixth Circuit in federal appellate courts, your case is originally heard by 3 judges. And if the whole court decides they disagree with those 3 judges, they can reverse that decision. So that would have happened next. The whole court had actually determined that it was going to rehear our case, but the case settled before they got to that point. And then after that, it could potentially have gone on to the US Supreme Court. But we were able to settle the case with Governor Whitmer of Michigan. And so that's where it stands now. But those 3 cases that Dana discussed were the critical foundation to our case in Gary v. versus Whitmer, and really, form the kind of backbone of constitutional doctrine in terms of what education is provided to students.
Thank you so much, Tacy. So that's, for the audience, right, this is what is often referred to as impact litigation, because it can have the precedent established by the courts can have a huge impact on what happens moving forward in real life, right? The kind of funding schema that we have for public schools could be impacted by these sorts of decisions, et cetera. Amy actually litigates on behalf of students on a day-to-day basis who are being denied various access or are having challenges to their access. And she deals with a bunch of other cases that I'm not nearly as familiar with that she's going to speak to about historic precedent and how they impact her day-to-day work. Amy?
One thing, as Tacy, as you were talking, that I've been thinking a lot about is in this sort of current era of the COVID pandemic and a lot of schools going to remote learning. I think this question of what it means to have even sort of a minimum level of access to education is, incredibly relevant, given that, despite the best efforts of many school districts, there are so many students who still don't have access to a device at home, who don't have access to reliable internet, who don't have a quiet place to do online learning, and I think are facing kind of really analogous questions about whether or not they're even getting the sort of minimum access to education. But turning to some of the other rights that students have that we seek to protect. So as Tacy and Dana mentioned, there's never been a US Supreme Court holding that students have a fundamental right to an education. At the same time, the Supreme Court has, repeatedly said that students' rights don't stop at the schoolhouse door. And and the Supreme Court and federal courts have played an enormous role in determining what rights students have within schools. And so that includes, first of all, the due process rights. So in Goss versus Lopez, the US Supreme Court determined that students did have a property right to an education. So that, given that states do provide public education as a service, they can't take away a student's right, the property right, without some kind of notice, some kind of hearing, and some kind of opportunity to be heard and to engage with whatever the evidence or the charges are against them. And the framework that the Supreme Court set up in Goss versus Lopez, which is distinguishing between students who are expelled or suspended for 10 days or more as sort of a long-term suspension or an expulsion, and that sort of a line where students have more, closer to almost a sort of court-like process where they need to get a more formal written notice, they have to get a more formal hearing, they often have to at least have some opportunity to cross-examine or question witnesses against them, and to have advance notice of what the charges are. And then even for students who are being suspended for less than 10 days, the Supreme Court still said that they have some level of due process rights. So even if that's a more informal opportunity to kind of engage with whatever it is that they've been accused of, they do still have those rights. And that case is from 1975, but still, you know, sets the framework really for how we deal with student discipline today. There's also, in terms of rights that students have, free speech rights, First Amendment rights are another important area where you know, the Supreme Court has affirmed that students have the constitutional right to freedom of speech. So the leading case there is Tinker, which was a case where the Supreme Court held that the school districts couldn't abridge the students' rights to wear a black armband in protest of the Vietnam War. There wasn't any evidence that that would cause a disruption. It was purely a free speech issue. At the same time, I want to note that courts have granted a lot of deference to schools, to teachers and administrators in determining kind of what the contours of those rights are. So both for Goss versus Lopez and Tinker, there's a lot of emphasis on this, on the rights of schools to sort of contain disruptive students, and that if a student is deemed to be disruptive, that, you know, that gives courts or teachers and administrators much more leeway to, you know, to discipline them for speech that's deemed disruptive or for behavior that's deemed disruptive. And, you know, I think one thing that we've seen is that there's a lot of implicit bias in what is considered disruptive behavior. So, you know, overwhelmingly, we see Black students disciplined for disruption, for behaviors that white students are not disciplined for, and that's, you know, really a concern and an area where, because courts have granted so much deference to schools in this area, where it's been really difficult to really sort of full-throatedly protect students' rights in these areas. Turning from the constitutional rights that students have, it's also, you know, I think important to acknowledge that students have a lot of statutory rights, and that's another area where courts are really important, is in interpreting statutes and how they apply to students. So, for example, on the federal level, there's the ADA and the IDEA, which really protect students with disabilities, and actually do set a minimum level. So students with a disability are entitled to a free and appropriate public education, and actually can seek things like compensatory education and other remedies if their education falls below that minimum level. So that's an incredibly important statutory right, and one where court cases have been really important in sort of laying out what level of minimum education and what types of students are protected. So, you know, one case that's gotten a lot of attention recently is the Peter P. versus Compton Unified School District. So that's from 2015. And that is another impact litigation case brought on behalf of a group of students in the Compton Unified School District, alleging that those students who'd experienced complex and multiple traumas relating to poverty, being in the foster care system, familial abuse, violence, and that those sort of repeated adverse childhood experiences or traumas had actually created impairments or conditions that needed to be accommodated through the disability laws. And that's a case that then has been used by advocates to advocate for accommodations for trauma in other situations. So for example, trauma relating to sexual harassment or sexual assault that students experience, or trauma that students on Indian reservations have experienced as part of their community. And so that's a situation, I think, where a strong federal statute has really been used by advocates in the courts to protect students' minimum rights to education.
Thank you so much for that background. Right, constitutional laws look so different depending on what frame you're looking at them through, right? Amendments or statutes, federal precedent versus local court precedent. So one of the things that we talked about in preparing for this was if there are any trends. Based on what Carol was talking about the diversity of appointments to the judiciary in the Trump administration, it appears that it's getting more white and male. Has that had any impact on your work?
So I can start. I think that increasingly the federal judicial landscape has changed, and we've seen that in the Seventh Circuit and in some of those appointments, and increasingly. I would say our organization has looked to state law, to state courts, and state statutes, as well as as well as the state constitution. As Tacy mentioned, advocates have for a long time looked at state constitutions as a way to protect a minimum right to an education. In Illinois, we unfortunately don't have one of those really excellent state Supreme Court rulings protecting the right to an education under the Illinois Constitution. But that's an area where there really has been a positive trend, even in recent years, of state Supreme Courts, like in Pennsylvania, actually even revisiting this question and finding for the first time that that students do have a constitutionally protected right under the state constitution. And a lot of that has in some ways been following kind of the trend of state legislatures to pass much more detailed standards around education. And I would argue that we are ripe for that kind of reconsideration in Illinois as well, that with the evidence-based funding statute, with our more detailed state statutes, that this is a moment where it may be ripe for the Illinois courts to reconsider whether this is now sort of something that's justiciable under the state constitution. We've also, given that we have a focus on racial justice and race equity within our organization, one of our state statute, state court tools, well, there are a couple. One is the Illinois School Code. We've had some really strong laws passed around protecting students' right to an education in disciplinary cases, and really setting a much stronger standard, much stricter standard for when schools can suspend or expel students, that we've really sought to use to its fullest in state courts. And also in our civil rights laws that we've seen, for example, we have a really good state law, a really strong state law around racial disparate impact, the Illinois Civil Rights Act of 2003, and that was a linchpin in our litigation to stop the closing of National Teachers Academy by Chicago Public Schools. So I think for us, we've seen state statutes, the state constitution, and state courts as increasingly an area of advocacy.
Yeah, I really agree with everything Amy said. Just to start on the trends in the federal judiciary, I don't think you could call it a trend to say that federal courts have not been have not reached out to hold that there's any kind of right to education. As I was saying before, the decision we were able to win in Gary B. Is the first time. And there were lots of courts under lots of different, there were many years with the federal judiciary of judges appointed by different presidents in which a decision recognizing a constitutional right of education did not exist. So I don't think that's really any kind of a recent trend. Certainly the judges that have joined the federal judiciary during the Trump administration are in general, more of an originalist sort of approach to the Constitution, which is to say that the Constitution provides what it provided what it means, what it meant at the time it was ratified, or at the time that any particular amendment to it was ratified. I think there's a prevailing wisdom that an originalist interpretation of the Constitution would be contrary to, would be inconsistent with recognizing of a right to a basic education. That's a prevailing wisdom that we definitely fought against as we were litigating Gary B. We argued, and there's some pretty strong research by originalist-focused academics as well, that there is support, even on an originalist reading of the 14th Amendment, for access to basic education. The panel that decided our case didn't really spend too much time on that type of analysis, but there are at least some threads there. But I completely second Amy's point about the trend in state courts of recognizing a privately enforceable right to education under state constitutions. And I think Amy made a great point about the shift in how education has happened, possibly leading to a shift in judicial interpretations of state and maybe even the federal constitution for in addressing education. So in San Antonio versus Rodriguez and the leading Illinois Supreme Court case looking at Illinois law, courts have said this isn't the kind of right where we're going to engage in strict scrutiny. In federal courts, strict scrutiny is applied to certain kinds of classifications, like racial classifications, where if a law classifies different people by race, there has to be like a really, really good reason. And it's very hard to satisfy strict scrutiny. So courts analyzing education cases say, we're going to use rational basis review, where as long as a law that gives some people more money than other people in education has a rational basis, then it's okay. And courts say there is usually a rational basis, which is local control. There's a value in having, towns or individual school districts or counties or whatever. There's a value in having local groups make decisions about what taxes they want to levy and how they're going to handle education locally. And because there's some value there, we think it's rational for states to set up their systems in a way that means some districts have a lot more money than other districts. Like, for example, if funding turns on property taxes, because obviously some districts have higher property values than others. But that's really changing, as Amy said. There's a lot more centralization of how education is run in states, with Common Core and just state-based standards that were much less prevalent a few decades ago when these decisions came out. So states have been much more fertile ground for education cases, rights of access to education or access to adequate educations. And maybe they will be even more fertile grounds going forward as as courts recognize that education is not really a local business, not nearly the way it used to be anymore.
Thank you both for those comments. I did want to just register for folks in the audience who aren't familiar with the justiciable term. It's when I was talking about San Antonio v. Rodriguez and the court sort of saying, this isn't our area of expertise. We can't say that less funding is actually directly correlated with a lower quality education. As state Supreme Courts have come out and ruled on what is sufficient to be called adequate or quality or efficient, right? There are different terms that state Supreme Courts use to describe the public education that the state has to provide. And as courts come out with more and more opinions with multiple factors that tie into a quality education or a sufficient education or an equitable education, it becomes more and more the issue of what qualifies as a sufficient education becomes more justiciable. Also, as it's studied and reports are issued indicating what level of education folks are receiving. So the Detroit schools, right, you need to have reports indicating that those kids are graduating essentially illiterate in order for the court to be able to opine on whether or not they're receiving even a basic level of education. So the more statistical analysis is available, the more data is available, the more the courts feel entitled to have an opinion, and then the issue becomes justiciable. We've talked a lot about historic cases, current trends in the courts, and we've gotten to this point in a variety of ways, but perhaps we should summarize the impact of court decisions on our communities. And I think Tacy made a great reference as far as property values, right? As long as our school districts are funded by property values, then historically under-resourced communities are going to continue to have under-resourced school districts. And this is one way that many people have argued that systemic racism is baked into the way we provide public education based on local property taxes. But so that's my pitch for how the court decisions, as long as we uphold that method of funding, we are upholding historic systemic racism that's hundreds of years old. That's my pitch for the impact that court decisions are having. What do you guys think about the impact of court decisions on our communities?
Well, Dana, at the outset, you were talking about how you were talking about Brown versus Board of Education. You mentioned that schools are now as segregated or more segregated than ever before, despite the absence of laws imposing racial segregation, such as those that existed back before Brown v. Board. So we don't have those laws anymore, thank goodness. But the way the court went on to interpret segregation and desegregation requirements after that has definitely affected housing patterns. So in a famous case called Milliken, the court held that you're not allowed, we know under Brown that you're not allowed to impose segregation by law, but we're not going to require you to desegregate across school lines, so school district lines. So if there's a town line between Detroit and a neighboring town in that case, and the neighboring suburb is extremely white and the Detroit schools are much less white, so it looks a lot like racial segregation, but the dividing line is a town line rather than a law imposing segregation. The court said, we're not going to require desegregation across district lines. The Constitution does not require that. And so the result is there's still a huge amount of racial segregation across district lines. And then in a more recent case in 2007, called Parents Involved in Community Schools, the Supreme Court actually struck down policies in Seattle and Louisville where those cities were voluntarily attempting to reduce segregation that resulted from housing patterns within the city. So the system was to consider race, the race of an individual student, in determining what school that student would go to if schools were becoming racially segregated, not by law, but as a result of where people went according to where they lived. If going to school where you lived resulted in racially segregated schools, the system would consider the race of students in determining what school to assign them to. And the Supreme Court said, we're not going to permit that. It essentially said, well, it literally said in an opinion by Chief Justice Roberts, the way to stop discriminating on the basis of race, is to stop discriminating on the basis of race. So it said, we're not going to let districts consider the race of the student in order to achieve racial balance, because we have determined that racial balance is not a legitimate grounds for satisfying strict scrutiny, as I was talking about before. So at this point, I think districts are pretty limited in what they can do to reduce housing caused racial discrimination. I'm sorry, racial segregation.
Yeah, I think the one thing that I would add to Tacy's comments is that we're in the midst of a pandemic that has, I think, deepened and laid bare racial inequities across so many facets of our society, and where we've seen those inequities play out in education and in access to the schools in a whole variety of ways. And I think even with a historic new funding statute in Illinois, we're still I think anticipated to get to adequate funding for all school districts by I think it was 2030, but now it's like even further away, unfortunately, than it was. But where patterns of segregation and housing discrimination have resulted in serious inequities, both among districts, but within districts as well, where Black and Brown students are much more likely to be in households where they're doubled up, which is, again, going back to this idea of that if you need access to remote education, you need to have a quiet space where you can participate. That Black and Brown students and Black and Brown families are much more likely to be essential workers, to have expanded caregiving responsibilities for younger siblings, to face a digital divide and be less likely to have access to their own devices and to reliable internet, much more likely to be housing insecure or homeless, much more likely to be food insecure, in which case, the loss of access to meals or the challenges in getting meals if students aren't going to school creates another, really, and again, despite the best efforts of districts to distribute meals to students, I think, we've really seen the many ways in which schools have become hubs for social services in a variety of ways for students. And then when those schools are closed, the challenges that there are in providing those services to students, and with households where Black families are much more likely to have a friend or close family member who passes away due to COVID. We're seeing race inequities in students' mental health and trauma needs, which again is an area where schools are required to provide accommodations. And so I think, in so many ways, we're seeing the effects of, many racially inequitable policies really, coming together and impacting students and families, much, even more strongly than before during this pandemic.
Thank you both for those comments. I think that we've touched a great deal on the importance of diversity in the experience of education by students. And I think that, if not explicitly, implicitly, the importance of people understanding that, and especially judges who are making decisions on these cases. Do you guys have any additional nuggets of important ideas that you'd like to share on the importance of diversity on the bench?
Well, I had just one thought. I think it's clear that among the nominees to federal courts, there are a lot of corporate lawyers and prosecutors. So lawyers from large law firms, and I am one of those, so I certainly don't think there's anything wrong with those people, and prosecutors. Prosecutors are great, large law firm lawyers are great, but there just aren't nearly as many lawyers engaged in other types of legal practices, like public defenders, like civil rights lawyers like Amy. There are some of those, they're just they're not as heavily represented among judicial nominees as corporate lawyers and prosecutors. And so that's a form of diversity that, you know, could really change the shape of the federal judiciary if we had people with experience in different forms of legal practices before they got on the bench. Oh, and politicians, that's another type of lawyer that people talk about. There used to always be, I think historically there were a good number of politicians on the US Supreme Court, people who were, by politicians I mean people who were elected to political office, and there just aren't those people anymore. The entire court now is people who've been judges or practicing lawyers or professors for their career.
Amy, anything you'd like to add?
You know, I'd just say that diversity is important in schools. It's important in, you know, in our teaching staff and school administrators, and it's, you know, important on the bench as well.
I totally agree. And from my personal experience, having a student who went through CPS, we were able to take advantage of the two-tier system of the public education through sophistication and access to only incremental disposable income through music lessons. And then like if we hadn't had the $50 to rent a trumpet, my son wouldn't have had the music lessons, right? And then he engaged in a trumpet audition to get into Lincoln Park, which had wall-to-wall IB, international and baccalaureate. And so finances and sophistication can get you far, even if your local district doesn't have doesn't offer the best education. And finance and sophistication are in short order if you're living under the poverty limit, working multiple jobs, have more of a care burden on you for family members, et cetera. So it's not a solution, right? And folks who have been through that kind of a background where they've had to navigate the system, you know, it would be great if we had more representation of those people on the bench so that they knew what it looked like, right? So we've addressed a great deal of the agenda here. I don't see any questions. The one question that Carol and I had contemplated was, where are the plaintiffs in Gary B. v. Whitmer today? How are they doing? What are they up to?
Well, part of the settlement was a trust for the named plaintiffs to obtain remedial education. So that's excellent. They will be able to make up some of the shortfall of their years of experience in the unfortunate conditions that their schools were in. You know, one of our class members was a really smart, talented kid who went to college after graduating from high school, and you know, just was not prepared, and so didn't work out, and so he's now working, but hopefully will be able to, you know, get back to college and complete his education there with some remedial help.
You always wonder what happens,
Yeah.
you know, to these young people who were part of the litigation.
Right, right, and took on quite a burden. It's not easy to you know, stand up to say, I'm someone who, you know, faces illiteracy.
So, sorry, I've been joined by my dog in this. Well, let me sort of try and wrap things up with some thank yous and a few other things. First, let me start by thanking Tacy and Amy for your wisdom and your insight into this area, which is so important in all that we do and what we advocate for at Courts Matter Illinois. I want to thank Dana for being our very able moderator and helping us to even put this together, and we couldn't have done it without you. And behind the scenes, behind that Courts Matter Illinois banner, is Mike, who really, we couldn't do this without Mike. He keeps us going and makes sure things run smoothly, so thank you, Mike. and to, you know, our steering committee of Courts Matter Illinois, who also helps keep us going. And I want to again thank the co-sponsoring organizations who help us as well. I want to thank everyone who's joined us today for your participation, and remind everyone that our 5th webinar in this series on Courts Matter to Climate Change and the Environment, a highly appropriate topic as we are experiencing fires and hurricanes at the same time, will take place on Tuesday, September 29th. You'll be able to register for that webinar starting tomorrow. We have 3 panelists for that webinar, and we should be putting out the information as of tomorrow. So we hope you'll join us for that. We also hope you'll join Courts Matter Illinois. It doesn't cost anything, and you can be a part of us and help advocate for a fair and just judiciary. Check out our Facebook page, email us at courtsmatterillinois@gmail.com, and please, please remember that courts do matter. Join us, vote. Thank you, and have a great afternoon. We're glad you were with us. Take care.
Thank you so much, Tacy and Amy.
Okay.
Thank you.
Bye, everyone.
Bye.